Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Nur Akila binti Zulnun. My matric number is S51751. So today I will present on how I answering the model question of commercial law. I have choose two questions, which is question 1 and question 2. So for the question 1, it is about Ali, the youngest of 3 siblings, has been offered to study at University Malaysia Terengganu. So his 2 older sisters, Aminah and Alia, promised to provide him allowance about 500 ringgit monthly on the condition that their mother need to transfer some land for them. So and then their mother agreed to transfer the land for Aminah and Alia. However, both of them failed to fulfill their promise, and Ali sued them for the promise. So in this question, we need to advise Aminah and Alia. So for the question 1, the issue is whether there is a consideration or not between Ali and her sister, and is it the contract between them is valid or not. For the principal part, general rule, we know that an agreement without a consideration is void. According to the section 2D, consideration is a price for which one party pays to buy the promise or act of the others. And then for the contract to be legally binding, the consideration must be something that the promise is giving up, or something that give benefits to the promise. So in this consideration, there are 3 rules, which is rules: consideration must be sufficient, consideration need to be adequate, and consideration need not to move from the promisee. In this situation, the rule of consideration that need not to move from the promisee is related to this question. So based on this rule, if a person consider other than the promisee, then the promise cannot enforce the contract. So if the third party involved in the contract, the problem may occur during that contract happen. So however, in our Malaysian law, the promise or the third party that enter into contract, we can call it as a consideration. So in section 2D of contract, or Contract Acts 1950, provides that when the promise or any other person has done something or act, it is called consideration for the promise. So we can see this rule was applied in the case of Venkata Chinaya versus Verikatara Maya. So in this case, a sister agreed to pay an annuity of $650 and $53 to brother who provide no consideration for the promise. But at the same day, their mother had given the sister some land, so stipulating that she must pay the annuity to her brother. So the sister subsequently failed to pay the annuity, and it was sued by her brother. So the court held that she was liable, or she need to pay the annuity, because there was a consideration between both of them. So the application for this question is based on the given that I have been given in the principles and case. So in this case, the consideration was the action or the promise that made by the Aminah and Alia, or the other third party, which is her mother, which is, we can see that there is a consideration between them when there is something were given in return for to get something else. So in this situation, even though Ali did not give any in return, but the contract between them is valid. So it is related to the section 2D, which is contract acts, and the case of Venkata Chinaya, which is when the promise or any other person has done something or act, it is called as a consideration for the promise. So in this case, in this situation, we know that Amina and Alia need to pay Ali. So however, when if Amina and Alia cannot pay, Ali can sue them, or he can claim the promise, because the contract between them is valid actually. So in the conclusion of this question, we can conclude that Ali can claim the allowance because the contract between them is valid. So the Alia and Amira need to pay the allowance as they promised before this, or maybe Ali can sue them because they had breached the contract. Okay, for question 2, it is about Satok is a licensed hunter. He used to hunt for porcupines and ant bear and sold them to exotic food restaurant. He entered into a contract with Delhi Sushi restaurant for supplying of porcupines and ant bear on 31 August 2019. However, on the 5th September 2019, Parliament of Norway State passed a new law which prohibits any hunting and selling of porcupines and bear. Satok was aware about the new law and wishes to discontinue the contract, and so from this question we need to advise Satok. For the issue is about whether the contract between Satok and Delhi CZ restaurant can be discharged or not. This is in the topic of the discharge of contract. So for the principal part is a contract may be discharged by frustration. According to section 57 Contract Act 1950, frustration is any impossibility of performance after the contract has been made by an unforeseen event occur or something radically that can change the circumstance and the contemplation of the party at that time, the contract may be discharged. So means that after you enter into a contract, if something happen or some event occur which is it make you impossible to perform the contract, then that is the frustration in the contract. So to make you more understand, frustration it is not about you choose to not perform the contract, but something happen outside of your control, which is it makes you impossible for you to proceed the contract. In this question, there is an event occurs which is the event based on supervening illegality. So supervening illegality means that there is change of law which is that make it illegal for you to perform the contract. So we can see it is applied at the case in the case of Avery and Borden, which is the agreement to supply a cargo for a ship. In this case, when the ship arrived at the Odessa, the master request a cargo, but the agent could not supply it. So when they argue themselves, during the argument there is a war happen at that time. So the government made it illegal for them to load the cargo at an enemy port. So the ship could not perform its contract because of the law. So that's why it is apply or it is related with the supervening illegality. Maybe to make us more understand about what is supervening illegality, we can see the example which is around us. The government give us an order which is to control our movement due to the COVID-19. So all the business need to shut down or need to close down their business, so they cannot to perform or they cannot deliver their service and goods to the customer. So due to this change of law, all the contract that have been performed during that period are frustrated, which is the contract during that time will end automatically, which is the party do not need to proceed the contract anymore. So because of the law, the contract can end or the contract can discharge. For the application for this question, we can see that Sato enter into a contract with Delhi Restaurant on 31 August. So during that time there is a contract between them. However, on 5th September, the Parliament of Norway State passed a new law which prohibits any hunting and selling of porcupines and bear. So on the 5th September, there is change of law, which is that make it illegal for Sato to perform the contract. So when this something happen, which is this event happen during the Sato enter the contract, so the contract was discharged because of the supervening illegality. This contract we call it as a discharge by a frustration. So Sato wishes to discontinue the contract according to the section 57 through all the principle and case that I have been given before this, which is Sato is under the supervening illegality, which is make he can discontinue his contract, which is the contract is frustrated due to the change of the law. So yes, Sato can discontinue the contract or he can end the contract because of this supervening illegality. So the conclusion of this question is, it is clear that the discharge by the frustration is considered by an event and the contract will end automatically. So because of the event that occurs or something radically that can change the circumstance, the contract can be discharged and they did not have to perform the contract anymore. So that's all for me. Thank you.